Seat.
We are.
All right. Court is calling 2023 CR 7760, State of Texas versus Destiny A. Valadez. Can I have parties announced for the record for the state? Defense.
Matthew Brown, Your Honor.
And are you Miss Destiny Valadez?
Yes, ma'am.
All right. You entered a plea on August 12th, 2024, no contest. According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. The state is silent on your recommendations. On your recommendation. The state took into consideration 3 cause numbers. Both parties agreed to waive the PSI and just proceed on the TAP evaluation. Have both parties had a chance to review the TAP evaluation, state?
Yes.
Defense?
Yes, Your Honor.
Any objection to the TAP evaluation, state? Defense?
No, Your Honor.
All right. State is silent. Defense, do you have any witnesses?
We do not, Judge. Just argument, and if you would like to inquire of the defendant.
All right. The court will hear argument.
So, Judge, having looked back at her criminal history, which is one of the things that you ordered 2 weeks ago when we were...
At first glance, the defense seems to have a solid strategy, highlighting an old criminal history and asking the court for probation instead of jail. But judges don't just look at the past. They're trying to predict the future. The real question is whether this defendant has actually changed, or if the risks still outweigh the second chance.
Here.
Yes.
There is some history, and we can't deny that. But if you go back and look at it, it's the most recent cases outside of the current ones were from 2016, and those are simple failed ID cases.
Okay.
There are no felony convictions for Ms. Valadez. There's a couple of items from 2013, 2011, 2010. So it's pretty old things, and it's all misdemeanors. We think that she would benefit from some structure, which I believe probation could provide her. She does have children that her mother is taking care of. She informs me, has told her that she could live with her. However, she's got to find a job before that happens. So Ms. Valadez has reached out to Haven for Hope and discussed with them the potential of living there should the court allow her to be placed on probation. And also we'd point out with the TAP that there's no drug and alcohol criteria for abuse or dependence, and that substance abuse is not, that treatment's not recommended at this time. So we would ask, based on those factors, that the court would grant the application for probation in this case.
All right. Anything you wish to say?
I just want to get a chance.
All right. You're whispering.
I just want to get a chance to help my mom, my kids, and be able to get a chance to get a job.
All right. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right. You can lower your hand. State your name for the record.
Destiny and Valadez.
All right. So you say you want to help your mom with your children? How many children do you have?
4.
What are their ages?
21, 12, 10, and 9. And I'm also her grandma.
Wait, 21, 12, 10?
And 9.
And I'm assuming you're the grandmother from the 21-year-old?
3 kids.
Okay, you're whispering.
She has 3 kids.
So she has 3 children. What are their ages?
5, 2, and 1.
All right. So maybe she was 20 with the 1-year-old, and then the 2-year-old, 19, and then we have a 5-year-old. Why is she having a child at that age? Where were you?
My mom actually adopted my kids.
All right. So why did your mom have to adopt your children?
Back in, let's say, 2012, I was going through some things with my father. Mental physical abuse with him. He's no longer a part of my life.
All right. So anyway, if your mother adopted your children, that means there probably was a CPS case, correct?
Yes.
All right. So that means that you didn't do your CPS plan.
I did my CPS plan. My mom talked to me that it was best to do the adoption. She pushed for the adoption. If you were to look into my CPS, I was not terminated my rights. My mom asked me if I would sign.
No, your rights have to be terminated in order for your children to be adopted. There can be no adoption without termination of parental rights. And I know CPS normally does not terminate parents' rights because their spouse or their partner is abusive. Where the termination comes in is when you're doing everything that you're supposed to do, and they tell you that you can no longer be with the abusive spouse. And usually people go back to the spouse. You're smiling when I say that. So what happened? All right.
This is where the hearing takes a dramatic turn. The judge starts comparing the defendant's story with the official court record, and the inconsistencies begin to stand out. In court, credibility is everything. Once a judge believes you're hiding the truth, every argument that follows becomes much harder to believe.
So why are you being dishonest with the court and making it seem as though, oh, they didn't terminate my rights. I did everything, and I wanted my mom to have my children, when in reality, they gave you a choice. You can go to jury trial. A jury will make a decision to terminate your rights or not, or either you can have your rights terminated and then someone else will adopt. And so what ended up happening is you chose your man over your children. That's what happened. So why are you pretending that you need to help your mother with your children when your rights have been terminated? She's the parent, not you. You are no longer their parent. You're their biological parent, but legally you're not their parent. And why are you stealing other people's identifying information? All right. Is there anything else?
No, Your Honor.
All right. This is what the court is going to do. The court previously stated the court had found you guilty. The court is going to sentence you to 2 years in the state jail facility. Give you credit for any time served. There's a $1,500 fine. Time and money will not run concurrent. The court previously, according to your plea bargain agreement, is taken in consideration the following JN numbers: 6788324, 6788325, 6788326. There's to be restitution and no contact with Christopher Geyer, G-E-I-E-R-A. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing.
The sentence is already over, but the judge isn't finished. What comes next isn't about punishment, it's a lesson. Instead of focusing only on the crime, the court shifts attention to personal responsibility and the consequences of years of choices. Sometimes these final remarks leave the biggest impact of all.
Stop using your children. Stop using your children to get out of criminal cases that are of your own making. You knew that legally you were not the parents of these children. You knew that your mother was raising them. You're not raising them at all. And if you truly love your children, which I hope you do, the choices that you've made up till now shows that you put yourself above your children and put a man above your children. That's why your mother has them. But do one thing in your life for them. And this is what you should do. Don't go stay with your mom because you're not having your life in order. You have no plans to get your life in order. You're just there to continue this cycle of using people. You need to stop. Go to the state jail facility. Get your life in order. If you have a drug issue, get the drug issue in order. Don't come knocking on the door trying to be a parent. Don't go knocking on the door being a bad influence to your grandchildren. Do you understand? All right, good luck to you. Thank you, counsel. Do you have any children living with you? All right, and who is that?
Royalty. She's not far away.
All right. So I'm not going to allow you to live with Mr. Williams because he has issues of his own. You understand?
Yes, ma'am. I don't, and I want to let you know, we're not together no more, nothing like that is going
When
on.
did that? You need to speak up. When did that end?
I would say about a month ago.
Because you were just here with us by Zoom, were you not?
Yes, ma'am.
And when was that?
Thursday.
Thursday. So who are you living with?
No, we are in my apartment. That's where we are at in Austin.
And who lives in the apartment with you?
Me and Loyalty, he doesn't stay there anymore. He's back in San Antonio.
No, that's not what you said on the Zoom. I will tell you, my mind is a steel trap. I remember you being on Zoom and I remember you saying that you lived there with him.
Yes,
And my
ma'am.
issue was that you all were jumping from place to place to place.
Yes, ma'am. So we were living with him at first in San Antonio. Then we moved to Austin. I stayed in Austin. He left back to San Antonio.
Deputy Laura, can you look this cause number up and tell me if he is in custody? It's 2018 CR 12116. All right, so he's not here in Bear County because if he was, there's a warrant for his arrest and he would be here. So he's not here.
He's not with me,
No.
so I don't know where
All
he's
right.
at.
So you need to come back to Bear County because you're not in a stable situation and you're not even stable where you are because you say the lease is not even in your name because of your issues. So you need to come back to Bear County. You understand? All right. Bashan,
Yes, Your Honor.
on this case, I'm giving her 14 days to get back to Bear County. Do you understand?
Yes, ma'am.
And you are not allowed to move anywhere else without my permission. So if there isn't something on your paperwork that says Judge Boyd is giving you permission to move, you are not to. Do you understand? All right, so, and I'm going to explain something to you. I know sometimes people say, Judge, it's not your business that I'm moving all over the place and taking my child everywhere, but it is. And the problem is people don't understand.
This case may sound different, but the judge's focus stays exactly the same: stability and accountability. When probation is involved, every decision matters because the court isn't just monitoring the defendant. It's also considering the safety and well-being of everyone affected, especially innocent children.
Understand that children are people too. And part of my job when I take, people and place them on probation is to protect the community. And for some reason, people think protecting the community doesn't include children, that children have no rights and they should just go on their merry way on whatever adventures or misadventures their parents are taking them. So if you look at it objectively, your daughter has been taken from place to place to place. And Mr. Williams, he's not her biological father, is he? So I want you to think about how many men or how many adults you brought into your daughter's life that shouldn't be there. He is on probation for assault, bodily injury out of a felony court, and that's who you brought into your daughter's life. I don't know why people don't do background on people when they have children. You should stop bringing random people into your child's life. You understand? Probation, is there anything else that she needs?
Your Honor, she completed a parenting program that was for a 4-hour course.
Mhm.
Is that acceptable in the court's eyes?
What did you learn from that course?
Well, I took it in 2022. I can't say everything I remember, but it's as far as how you should treat your child and how to cope with things with your child, how to act around your child, what not to do around your child.
How not to bring inappropriate people around your child, which is what you did. She needs an updated course of parenting, a remedial course in parenting. So if there's another course for her to take, And it doesn't have to be the complete long course, but obviously she didn't get the point that you're not supposed to just allow random people around your child. So is there a course?
I'll look
Should we
into
try
it.
rainbows?
I'll talk to the CSO to see what we come up with, Your Honor.
Okay.
But as far as alternate amending conditions, is it okay that I just put parenting courts?
Yes.
And then,
And if you are not by case, what's going to end up happening is a warrant may be issued for your arrest. You understand?
I do want to point out, Your Honor, that her intensive outpatient treatment begins on the 12th of this month. So, and that will be in person as
Okay.
well.
Okay.
Here.
All right. And can you make sure that they do field visits?
Yes, Your Honor. How many times a month?
Let's start off with 1 time per month until she has at least been in outpatient treatment for at least 2 months. And if probation doesn't see any issues at the home, they can then do field visits as they deem necessary. Now, is there anything else you need? And how old is your child? All right, so let me explain something to you. She is 100% dependent on you to protect her, to bring good people into her life. You understand? You can't come first anymore. It has to be her because she cannot get a job on her own. She cannot take care of herself. She can't enter into contracts where she gets apartments on her own or any of that. She's dependent on you. You understand? All right. Is there anything else you need from me? You sure? All right. So in this court probation, to be successful, you got to communicate. If there's something going on in your life that you need help with, contact probation. If you feel they're not addressing that issue, then you can come to court, okay? All right, good luck to you. And my understanding, he entered a plea in 2 cases. Is that correct?
That's correct, Judge.
All right, the court is calling 2020 CR 2993 and 2023 CR 043W, State of Texas versus Adrian Soto. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
David Andre Woodard from Mr. Soto.
Are you Mr. Soto? And cause number 2020 CR 2998. You enter a plea of no contest to burglary of a habitation with intent to commit assault. According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison, and the state is opposing your application. And cause number 2020 CR 3661, you entered a plea of no contest to the offense of assault, bodily injury of a security officer. According to your plea bargaining agreement, the state is requesting that punishments be assessed at 8 years in the prison. They're opposing your applications. Have both parties had a chance to review the PSI report, state? Defense?
I have, Judge.
Any objections to the PSI report, state?
No objections. From me.
Defense?
No, Your Honor.
All right, any witnesses, state?
None from the state.
Defense?
No, Your Honor, aside from the letters that are provided to you.
All right, and for the record, the court has reviewed the letters that have been presented. The court will hear arguments, state?
Your Honor, based on the defendant's criminal history, he did pick up these felony cases as well as multiple misdemeanors that are also pending involving the same family. The defendant's conduct is escalating and continues to terrorize the family, including the complainants on this case, as well as her brother, her children, and her mother. And the burglary for habitation, a burglary to a habitation case, defendants alleged to have entered the house through a open window or through an unlocked window and grabbed the child from where he was sleeping at 3 o'clock in the morning. He's shown a disregard for the safety and welfare of the complainant as well as the children in the household. And it's the state's fear that if the defendant were granted probation, he would continue to contact the family and continue to violate any no contact orders that would be entered. I would believe that the only way to ensure the safety and the welfare of the complainants are to sentence the defendant to the prison.
Defense?
Judge, I reviewed the PSI and also talked to Mr. Soto this morning regarding the impact statement that's provided in the PSI, and I've asked him, since this incident, had he had any contact with the complainants? And since the incident, he stayed away from them. He does have 2 children with the young lady, He hasn't seen the children because of this incident, but he has not gone around them or their household. So I think he's shown that he can stay away from it. I don't think he needs prison to stay away from him. Since he's been on bond, since these cases have been pending, he stayed away from that family. Also, Judge, if you look at his prior history, he does not have any convictions for misdemeanors or felonies. He's 25, he is working, he has support, he has family members here in court with him this morning, he has the letters that were provided to him. I think when we pled on the case, Judge, the court asked him if he was experiencing any substance abuse issues at the time of the offense. He was truthful with the court. He said, yes, Judge, I was under the influence. I also asked him this morning if the court did testing, how would he come up? And he explained to me he would come up negative. He has not been using any type of substances since he's been on bond, since these cases have been pending. He's working as a painter. He's not on child support for the children, but he is willing to place himself on child support so he can start contributing to their well-being. Also, Judge, the TAP evaluation, I noticed that it is recommending inpatient treatment. If the court did grant his application for deferred, we would ask the court to first see how he does in intensive outpatient treatment, because he's shown that he can stay drug-free. But I do think he would need some assistance with that. Even though he's been doing it since he's been on bond, we would ask the court, if the court did grant his application for deferred, to place him in intensive outpatient treatment prior to placing him in inpatient treatment. He accepted responsibility for both offenses. He pled to these cases. And now we're here before the court asking the court to grant his applications for deferred.
All right, so this is the court's issue. And not really an issue, but these are things that I think of. All right, so he has a felony offense, and I'm assuming this is being taken.
The defense has made its case, pointing to employment, family support, and recent good behavior. But judges often examine patterns instead of promises. One positive chapter can help, but it doesn't erase a long series of serious allegations. Now comes the moment where every prior decision is weighed together.
Taken in consideration the violation of an order, protective order. That's from December 31st, 2019. The burglary that he pled to is from December 27th, 2019. So let me go in order. So he has a continuous violence case that's December 14, 2018. I'm not saying it's true because nobody pled to that, but that's what he's charged with. Then after that, you would think something would click. Hey, I just got arrested, because I know he would have gotten arrested on that and made bond, and he would have gotten an attorney. So you would have thought that something would have clicked with that. But what ends up happening is on December 27, 2019, he picks up this burglary. Then you would have thought something clicked with that. But then what ends up happening? He picks up the violation of the court order or bond order or protective order on December 31st, 2019. And you would have thought that it would have been like, hey, I need to be on my P's and Q's because I picked up all these felonies. I understand relationships, and sometimes people don't love each other anymore and they have children and they got to make it work for the children, or they got to stay respectful to each other because they got to raise children together. And as everybody know, even though people say, we only need to be with each other for 18 years, but people know sometimes you need to be with certain children till they're like 25 or 30. I understand that. But then what ends up happening? He ends up picking up another case that he pled to, which is the assault case, on September 17th, 2022. So he has some issues. And I don't think that probation at this time is appropriate for him. Is he on GPS?
He is, Judge, and since he's been on GPS, he has not violated the GPS.
Oh, because he's on GPS because of this. And I'm not the judge who gave him probation for continuing to pick up cases. Some other judge did that, and the only thing I came back to do was probably add the GPS so that everybody would know where he was. So I'm not inclined to give him probation. I'm not going to give him probation. I'm going to sentence him, and I will retain jurisdiction. So, in cause number 2020 CR 2998, court will find you guilty. Court will sentence you to 5 years prison. Give you credit for any time served. All right, we can go off the record. I'll retain jurisdiction.
Both cases, Judge?
Yes. Sometimes, it is about it's always about rehabilitation, but it's also about protecting the community, and it's also about punishment.
Even after denying probation, the judge ends on a surprisingly human note. The justice system isn't only about consequences, it's also about the possibility of rehabilitation. Whether this defendant uses prison as a turning point or wastes another opportunity is a choice only he can make from here.
Sometimes people think the justice system isn't about punishment, but really, all these cases, there's an air of punishment involved, but hopefully rehabilitation. I know you probably think this is the end of the world. I came in here, I'm going to prison, but you're young, you still have a chance to get your life together. Please don't go to prison and get a bunch of tattoos because you're clean shaven now. Please let it stay that way, okay? All right, thank you.
Thanks, Judge.